Hello, everybody. We already have some participants coming in. That's wonderful to see. Would love it if you would go ahead and put your name and where you're coming from, like your city or your chapter name in the chat. And thank you all so much for being here. Hello, Carolyn. Welcome. Great to have you. Hey, all you new folks coming in. Thank you so much for being here. If you'd like, you can go ahead and put in the chat where you're coming from and your name, an organization you're with, if it's not SSA. Hello, Dave. Nice to see you. I see we might have had some shares in Colorado Springs. That's really exciting. Thank you. Hey, folks coming in. Thank you so much for joining us here. We'll get started in just a few moments, but for now, we'd love to know where you're coming from. So you can put your name and the city you're in or organization you're with or your SSA chapter if you're coming to us as an SSA member. All right, UNH. Oh, and in your chat window, if you change the to field to everyone, then everybody can see it, because I think most of you are just sending it to just me and Elizabeth right now. All right, St. Paul, Minnesota. Welcome. Good to see you here. And yeah, if you're just coming in, we'd love for you to let us know where you're coming from. So you can put that in the chat. Your SSA chapter or the organization you're with or the city that you're in. Ooh, from Yosemite National Park. That's cool. That's really cool. Got just a couple more minutes. And then we'll get going. Oh, wonderful. From PFLAG. That's so awesome. Thank you for the work you do. I love PFLAG to death. It's one of my most favorite advocacy groups. Helped me a lot when I was coming out in the 90s. Oh wait, I dated myself. Jeez, I shouldn't. And then also Greeley, Colorado. I'm a Colorado boy, and brother went to school in Fort Collins. So very, very good to see you here. And Connecticut. I think you're our first East Coaster so far. Oh wait, UNH, almost on the coast, really close. All right, we're almost ready to begin. One last call. If you'd like to share with us where you're coming from, what organization you're with, we'd love to know. So glad to see so many people here already. We've got, it looks like pretty much every region of the country represented. That's really exciting. And thank you all so much for being here. And again, welcome. You are now here for the Know Your Rights webinar hosted by the Secular Student Alliance. I want to thank Liz Cavell for being here, and it's going to give us an excellent talk, I'm sure, and we will have some time for Q&A at the end. If you don't know much about Secular Student Alliance, we are the largest national organization dedicated to serving non-religious students at campuses across the country. We have hundreds of chapters at universities and at some high schools, even middle schools, and we are making forays into elementary schools. So students of any age are welcome to join our organization. And we love our community supporters as well. We have tons of community support. If you're not familiar with SSA and you'd like to know more information, please check out our website. It's secularstudents.org, as you can see there. Also on the website, you can see information about our upcoming webinars. So this is the first in a series of webinars that we do every semester. And this semester, we have some ones that I'm really excited about. Christopher Cameron is going to be talking about Black free thought from slavery to civil rights. Dr. John Peters is a medical doctor and expert in evolution and is going to give us some of his favorite examples of evolution. And then one I'm particularly excited about, the struggle for abortion rights. So we're bringing together 3 activists from 3 organizations, one medical, one student, and one political organization that are going to give us a picture of the defense of abortion rights, what we need to do to win them back, and where we're at in that struggle. And then also in April, we have a secular Seder, and the Society for Humanistic Judaism is going to be supporting or hosting that along with us here at SSA. And it's a Seder without God, because you don't need a God to celebrate the liberation that the Passover holiday represents. Passover is my favorite Jewish holiday because you eat while you're celebrating, and it's all about liberation. So that's our series. Thank you all so much for being here. If you still feel like it, go ahead and put your location and organization you might be with in the chat. But without further ado, I'm going to go ahead and send it over to Liz. She is a there we go. An associate counsel with the Freedom from Religion Foundation. And thank you so much for being here. And please take it away, Liz.
Thanks, Matt. Everyone, you can hear me, right, Matt? I'm
Yes.
unmuted. Excellent.
Yes,
okay, let me just share my screen here. No, wrong thing. Sorry, everyone. As I pleaded to Matt in the setup, I'm older than I look and I am terrible with tech, but I will get there. Here we go. Share screen. Here we go. Okay. Okay. Matt, that looks good.
I'm not seeing it
Really
right now.
Oh,
make sure you're sharing either your whole screen or whichever window you have open.
Okay, just a minute.
There we go.
Got it. Okay, sorry everyone. I'm so sorry. Okay, here we go. Okay, hi everyone. So I'm Liz Cavell. Like Matt said, I work at the Freedom from Religion Foundation. I'm associate counsel there. And if you've never heard of me, I've been an attorney at FFRF for the last 10 years. Prior to that, I was a deputy public defender in Southern Colorado. And I live here in Madison, Wisconsin. That's where I'm appearing from tonight. And that's where FFRF is headquartered. So I wanted to do this presentation, and I'm so glad to have the chance to speak through Secular Student Alliance, because it's so important the way that the last couple of years of Supreme Court decisions have affected and changed really in the 10 years that I've been at the Freedom from Religion Foundation. Unfortunately, for better or worse, the law has changed a lot in terms of what the Constitution permits and requires, and what the rights of students are in public schools. I know I'm speaking to a lot of college students probably tonight. A lot of what I'm going to talk about tonight is really grounded in public secondary schools, so high school age, because that is the most recent case that the court grappled with this past term. And I really want to cover that because it changed the law in a lot of really important ways. So keep that in mind. But of course, we can talk later about how this affects students in other contexts at different age and grade levels, and what the law was prior to this past Supreme Court term. So I'm sure everyone is reeling from the past Supreme Court term, not just for the religion cases that the court took, but obviously Roe versus Wade was overruled. Gun rights were greatly expanded, lots of seismic shifts in different areas of law, and contraction of civil rights in several alarming ways, not the least of which in the religion clause cases. So the court took a few cases involving the First Amendment and religious rights, but the one I want to focus on tonight is a really important case that most of you have probably heard of if you're into this sort of thing, which is the Kennedy versus Bremerton decision out of Washington State that went up to the Supreme Court and was handed down last summer in 2022. And importantly, what it meant, what it changed in terms of the Establishment Clause and how courts evaluate violations of the Establishment Clause. For decades, we've all been sort of living and operating under a case called Lemon, and a test that was really put forth in that case. And what it did, it was a case in the 70s that really gathered all of the Establishment Clause principles that the Supreme Court had been analyzing cases under for decades, since the 40s, and put it all into one framework and a test of sorts for courts to analyze government action and determine whether or not that action violates the Establishment Clause by either endorsing or promoting religion through an official government action. And that was most sort of vigilantly enforced by courts in the context of public schools. And the case that the court took last summer was a case in that context, in a public high school, the Bremerton versus Kennedy case. You probably heard or read about the case and are familiar with it, but for those that are not, it took place in a Washington State high school, and it involved a high school football coach that had a long time practice of praying with students, both in the locker room and on the field. And his sort of signature team ritual was to pray midfield at the 50-yard line after games and invite students both on his team and the opposing team to pray with him. The district, when it was brought to the district's attention from parents of students, the district rightly told him he needed to stop and that his conduct was creating liability for the district because, of course, he's acting in his official capacity as a district employee when he's in his role as a public school coach. So he did end up stopping the conduct that was locker room prayer, organizing students for prayer in the locker room and praying with students. But he refused to stop praying on the 50-yard line. And there was a lot of factual back and forth, but the long and short of it is he sort of turned himself into a martyr for his cause. He was active in local media, sort of telling people he wasn't going to stop praying and that they should show up and support him. There was that fall in the games, there were state legislators that showed up to pray with him at midfield. There were games during this period of time when he was in dispute with the district. There were games where people at the end of the game, spectators, rushed the field. It was a huge hazard and a circus. And he, led opposite team, local government actors, and fans in these huge prayer circles with the media present, of course, at his beckoning. So throughout this process, the district tried to accommodate his own religious practice by sort of suggesting and negotiating ways, times, places, and manners in which he could pray on his own. He insisted that his religion required him to pray midfield at the 50-yard line publicly. So, and that students couldn't be stopped from joining him. And again, he had a history of leading students in prayer in this way for years. So this case, rightly, the way this case came to be was he did not renew his contract wasn't renewed after all of this. He was placed on administrative leave, and he then moved to Florida during the pendency of this litigation, which normally would moot a case because the relief he was asking for was his job back, but that's another story. So he lost and the district won. This was him suing the school district for not renewing his contract. The district won at the district court level, the appellate court level, and then the Supreme Court took this case, which was, of course, not a good sign. But it was argued, and the decision came down over the summer. This was a week after, I think, the Roe decision. So it was a rough couple of weeks. So what happened in this opinion was that, like so many from the recent terms, it was a 6-3 opinion. It was written by Justice Gorsuch. And what we all found really disturbing about the opinion was that the court always does sort of a recitation of what the facts were. They don't find the facts because the facts are in the record and they're not the trial court, but they're recognizing what the facts are and then analyzing the law based on what the facts are. And in this opinion, the majority completely lied about what the facts were, and ignored the context, the history of this coach praying with students, and just chose to focus in on 3 specific games in October of that football season where Coach Kennedy was praying on the 50-yard line in a manner that the court described as private and personal, and that the district, for punishing him, I suppose, by not renewing his contract, was violating his constitutional rights, both his free speech rights and his free exercise rights, and finding that his conduct in this case was doubly protected conduct because it involved both speech concerns and religion concerns. So religious speech is doubly protected. And the court just really swept aside any Establishment Clause concerns that the district rightly might have had by just completely casually killing off the Lemon test and saying, this court long ago abandoned Lemon and its endorsement test offshoot, which is not true. Lemon had never been overruled prior to this case, which is why lower courts found in favor of the district that they rightly were concerned about their own Establishment Clause liability. But the quote here that Gorsuch wrote is, a government entity sought to punish an individual for engaging in a brief, quiet, personal religious observance, doubly protected by the free exercise and free speech clauses. And so the Constitution does not tolerate that kind of discrimination. So the opinion went on and on about how school districts are wrong about what their Establishment Clause obligations are, and that there is no use in the factors Lemon put forth, which had a lot to do with endorsement, whether or not a school would reasonably be seen as endorsing religion by the conduct. So obviously, a team ritual being led by the team coach is reasonably seen by students and spectators as something that is being done with the endorsement of the school. The court cast that aside and any analysis like that for a historical practices and understandings test. The court says that the Establishment Clause violations going forward need to be analyzed by reference to historical practices and understandings. That leaves little guidance to school administrators on what constitutes an Establishment Clause violation. And the answer is for this court, probably not much. But really important points were raised by the dissent. Again, this was 6-3 along partisan lines. The ultra conservative Supreme Court majority is very far to the right, very far to the conservative side in terms of its religion clause jurisprudence. And we see this affecting many myriad areas of law, not just directly Establishment Clause jurisprudence, but we'll see it come up this term in the 303 Creative case, which is another anti-discrimination law case in the wedding industry, having to do with whether or not it violates the free exercise rights of business owners to be subject to their own state's anti-discrimination laws in public accommodations, businesses, wedding vendor businesses. And we're seeing the free exercise religious rights, that side of the religion clauses, being elevated for the individual plaintiffs, conservative Christian plaintiffs, and the subordination of the Establishment Clause interests of the rest of us and the government entities that are trying to balance the tension between those two, what were once thought to be equally important clauses of the First Amendment. So Sotomayor's dissent really put into focus some of the really alarming issues with this opinion, and and bringing to the fore some of the really big changes that are being brought on by this majority opinion in Bremerton. So I wanted to spend some time or use her dissent to illustrate some of the issues that we're all going to see going forward as a result of this case. So this picture, what was very special about this dissenting opinion is you don't often see justices pasting photographs in their Supreme Court opinions. This is the one opinion that I can recall in my 10 years reading constitutional law decisions where Sotomayor or any Supreme Court justice felt the need to put photos into her opinion to push back against the factual gaslighting being done by the majority. So this photo appeared in her opinion, and is a photo that in the middle there in the blue jacket is Coach Kennedy. And you see obviously all the players, the majority of the people around him, the athletes, are students, obviously. This is what the court described as brief, private, personal prayer. And Sotomayor calls out very candidly in her dissent that the court is completely misconstruing the facts in order to reach its desired conclusion and analysis. A really powerful quote, which is the last line of her opinion, was, "As much as the court protests otherwise, today's decision is no victory for religious liberty." But what's really important is that she used images, this one and another one, to visually put forth the fact that there are facts on the ground in this case that this majority is completely ignoring or distorting, and context that it is ignoring purposefully in order to support its analysis and its desired conclusion. Another thing that she is calling out here in this quote is the court relies on an assortment of pluralities, dissenting concurrences, and dissents by members of the current majority, meaning this court is citing itself in non-majority opinions to affect fundamental changes in the court's religion clauses jurisprudence, all the while proclaiming that nothing has changed at all. Again, it's not an exaggeration to say that this is gaslighting by the court. And this, on this point, it's the way that the court sort of kills off the lemon test, but also saying that the case was long ago abandoned. In other words, not acknowledging that this case itself is overruling decades of precedent, but sort of just casually claiming that it was already somehow overruled or abandoned by the court is a really odd tactic, and not the typical way that Supreme Courts are supposed to regard past decisions of the court. Obviously, our court is supposed to operate by stare decisis, which is abiding by past decisions of the court. Sotomayor is pointing out that the court is telling us all that nothing has changed under the law, while also making these seismic shifts to the way the religion clauses are analyzed. And finally, Justice Sotomayor points out, really importantly, what the court ignores about coercion. Excuse me. One of the most important principles of the Establishment Clause is that government cannot coerce directly or indirectly, in this case and context, students into the religious observances or preferences of teachers, coaches, authority figures in the public school context. And coercion is such an important component of why the court has been so vigilant about protecting public school students from religious promotion by school authority figures, because as Justice Sotomayor points out in her dissent, students are under immense social pressure, in addition to how much power is wielded by teachers, coaches, role models, administrators in the student authority figure relationship, right? The power dynamic is immense. And of course, in the case of coaches, but not only coaches, teachers as well, as she points out, students also depend on this approval for tangible benefits in the coach context. Players recognize that gaining the coach's approval may pay dividends, small and large, from extra playing time to a stronger letter of recommendation to additional support in college athletic recruiting. In other words, when the coach says do something, you do it, and it doesn't matter if it's optional or voluntary. And that's because the relationship between players and their coaches in the public school context and teachers and students is inherently coercive. And that is something that the court here, again, sort of in gaslighting fashion, the court in Bremerton versus Kennedy says that there was no coercion in this case because of its false facts, because Coach Kennedy didn't pray with students in these three isolated prayers, and he didn't require students to pray with him. No students felt coerced to do so in these instances. And this looks nothing like cases where the court has found public school prayer to be coercive, like in graduation or in athletics where prayers have been broadcast over the loudspeaker. Those are both Supreme Court cases where school prayer has been found to be unconstitutional. And the court here in the Kennedy case says we're not disturbing those cases at all. The conduct in this case is distinguishable from those instances because there's no elements of coercion in the situation here, which is bollocks, which is what Sotomayor is pointing out, because that photo of the group praying there, that is literally the hallmark of public school coercion, right? Like, and students said in this case, parents that complained said, my student is joining the prayer group because he doesn't feel comfortable not joining the prayer group, right? He doesn't feel comfortable going against what the team is doing. He doesn't want to select himself out of the group and draw the attention of the coach. Obviously, the coach is clearly indicating his preference for this practice. And so my kid wants to curry favor with the coach. And so he's doing this, even though this doesn't represent his own personal religious practice or preference. So coercion is a really big deal. The court brushes it aside and says it's not present in this case. And importantly, that's an element of the Lemon Test and the court's prior jurisprudence analyzing Establishment Clause cases. Coercion is one thing and factor that the court says still would violate even the historical practices and understandings analysis going forward. It just wasn't present in this case. And of course, the court doesn't grapple with the indirect coercion that is the hallmark of this situation and that has always been held to be very powerful in the public school context, especially amongst younger students in secondary schools and primary schools. So importantly, I'm glad that I get this opportunity to speak tonight. And that's because as part of our sort of post-Kennedy grappling at the Freedom from Religion Foundation, we are trying to push a Know Your Rights campaign to make public school students aware of what rights still exist, what rights they still possess in their public schools. And again, I'm speaking mostly about high school level and below, but of course, this does apply to some extent. And the courts have always been a little bit more less strict and more forgiving in the college context about what constitutes an Establishment Clause violation on the part of the college and university, public college and university, just recognizing that college students are older, more mature, more capable of understanding nuanced differences between individual professors' speech. There's more of a culture of academic freedom, a marketplace of ideas, a more mature student. And of course, courts have recognized that in the past, the decades past, in analyzing Establishment Clause violations at that level, even in public colleges. But of course, there always still had been and still are limits that remain on public colleges and universities going forward. But for all public school students, what's left after the Kennedy versus Bremerton decision, now that the Lemon Test is no longer the law of the land, there's this historical practices and understandings test that makes no sense because, like, at the time of the founders, we didn't even have universal public education. And so it's not helpful, and is if you follow this court, has become code for whatever the court and the ultra conservative agenda would want. That's what the historical practices and understandings would support. So it's not great, but it's important for students to know that there are still a lot of constraints on public schools after the Kennedy versus Bremerton decision in regards to the Establishment Clause and what schools can and can't do. So the fact that the court really made up facts and ignored the true facts and adopted what a Ninth Circuit Court of Appeals judge called a deceitful narrative. The fact that the Supreme Court adopted that deceitful narrative as its factual findings in this case is very disturbing. It's a whole nother presentation in and of itself about the court and what's happening. But for the purpose of figuring out and protecting student rights going forward, it's kind of a silver lining, because the court's untrue version of the facts and its characterization of Coach Kennedy's conduct is all that it actually approved of in the case. And so, in other words, it's not saying that coaches leading students in a big prayer circle is constitutional or does not violate the Establishment Clause or is not coercive. It's saying Coach Kennedy engaged in brief, private, personal prayer, and that is protected conduct and could not be seen to violate the Establishment Clause. That's not what happened here, but it's a good thing that the court has decided to give its blessing to only that conduct and not the true conduct underlying the case, because if we are all forced to play along and accept this decision, at least it means that the decision is cabined to the facts as recited by the Supreme Court majority. So there's that. The court did overrule Lemon, and so that leaves a big question mark for school administrators that are trying to conduct themselves in compliance with the Establishment Clause. And unfortunately, because many bad actors who are very eager to use their public school position to impose religion on other people's kids, most of those people probably are not going to read this decision or any commentary on this decision. They just see the headline, which is "Praying Coach Wins." Supreme Court says Coach prayer doesn't violate the Establishment Clause, whatever. Take the highlights and think, oh, I can pray now. There's a new Supreme Court. And so we are seeing a lot of bad actors just going right into gear and praying with students, reimposing prayer that was long ago stopped in public schools where we wouldn't have before, because obviously they are seeing signaling from the Supreme Court saying that this is okay. So part of our campaign on Students Know Your Rights is also re-educating school administrators on limits that still exist in the Bremerton versus Kennedy case, Kennedy versus Bremerton case, because if you actually read the case, it's not just a complete free-for-all in the public school context. It actually remains the law that praying with students or leading students in prayer in your official capacity as a coach or teacher still violates the Establishment Clause as far as the case is concerned and as far as FFRF is concerned. So we've been trying to re-educate schools, school administrators, as well as students about the limits now that the Kennedy case came down, knowing that most people are not reading the case and understanding the nuances in the factual findings and what the court did and didn't do. So some things that were true before that are still true is that students in public schools have the right to be free from coach or teacher-led prayer. That means the things that Coach Kennedy was doing before that he was forced to stop and that he even acknowledged he could no longer do, leading students in prayer in the locker room, having a teen prayer circle that was led by him and initiated by him, teachers leading prayers in the classroom, praying with students in the classroom, all of that remains unconstitutional under the Establishment Clause and undisturbed by the Kennedy decision. Secular school events, meaning prayer at graduation, prayer over the loudspeaker at sports, athletic events, and other school events like assemblies and awards banquets and other school-sponsored events. Those religious practices as an official part of school-sponsored events are still in violation of the Establishment Clause. The right to be free from bullying and harassment. This is a big one and getting bigger as religious actors in these positions of power are emboldened further. And this is why religion is a divisive force that we fight to keep out of public schools, because of course it creates division, and in an environment like a public, especially secondary school or primary school, bullying and harassment are inevitable. But you still have a right as a public school student to be free from religious bullying and harassment, especially by teachers. You have the right to be free from religious coercion. And what's really important about that is we are still taking from the Kennedy decision that religious coercion means more than just direct coercion. So it's more than just saying, if you don't pray with the team, you're kicked off the team or you're not going to start. It means more than just a direct threat or a mandatory participation requirement. It also means all of the things I talked about earlier, the indirect coercive pressures that exist around group prayer and other power dynamics that are inherent in some of these public school relationships. The right to freedom of conscience, which, of course, this is less of an issue with this court, but students have a right to their own religious beliefs or their own non-belief in public schools. They have a right to express their beliefs or their disbelief. They have a right to the freedom of conscience is broader than just religious rights, right? It's freedom of thought and freedom of expression and freedom of dissent. And all of those things, it's important for students to understand that they carry with them in public schools, regardless of how the Supreme Court is trying to contract the protections of the Establishment Clause. And of course, you have the right to complain about violations to school administrators, to boards of education, and also to organizations like ours. Of course, you can report a violation to FFRF, and our report site is there. It's a web form where you can report any public school action that you think might violate the Establishment Clause, or that you would like to just report and get an attorney to look at and let you know where it stands given the new landscape. But of course, you have the right to make these complaints and make your dissent known. Another part of our campaign was pushing back in the actual Bremerton, Washington area. So a big part of the only remedy sought, like I said, by Coach Kennedy was he wanted his job back. Of course, in the interim, he moved to Florida and spent all of his time traveling around the country, being a conservative media darling and appearing on various talk shows and giving interviews and, just gracing everyone with his martyrdom, and not living in Bremerton, Washington, or pursuing a teaching or coaching career. But of course, the Bremerton School District is required by the courts now to offer him his coaching job back, which they did. They didn't work it out for the fall. He said he was going to come back in the spring. So we'll see. But when the football season started, FFRF took out this billboard near the stadium, letting students know that they have rights and wishing them a safe and secular school year. And so we're still watching the Bremerton High School saga to see whether or not Coach Kennedy returns and what that looks like and what he thinks he's been permitted to do by the Supreme Court opinion. So that will continue into next school year. So I'm okay at 6:40. So I'm glad I'm wrapping up now. I want to leave ample time for Q&A, especially if there are questions about different contexts, different age groups. I know there's probably not a lot of high schoolers out there. So if you want to know more about how this opinion or other opinions affect you or something that has happened to you, we can talk about that now. But I do want to just reiterate, you can report any kind of state church violation or anything you want us to take a look at ffrf.org/legal/report. You can access a brochure, our Know Your Rights brochure that we put together after Kennedy at the URL there. I also want to plug the We Dissent podcast. I am a co-host of a podcast. It is a joint coalition effort of women attorneys in the secular movement. You can hear me on that podcast. It's monthly. If you really enjoy hearing about religion clause cases and religion law issues from a woman perspective, and it's all legal and weedsy, but I think it's pretty informative. So check it out at We Dissent. So I am glad, Matt, to take Q&A if there's any.
All right. Yeah. Thank you so much, Liz. And we do have a couple questions already in the Q&A. Participants should all know, or the audience should all know, if you hover down on your Zoom toolbar to the Q&A tab, you can type in a question there, and then we'll be able to see it and we'll be able to answer the question. You can also throw them in the chat too. But right now, there's been a couple related questions. Do you think increasing the size of the court would stop this assault on the Establishment Clause?
Oh, wow. Two questions on that issue. And I am so glad there is eagerness for this topic. I would definitely say that, at least on behalf of FFRF, we sort of actively and openly support court reform in various forms. Increasing the size of the court is one sort of element or idea for court reform. And I do think FFRF supports increasing the size of the court, but not only increasing the size of the court. If you listen to the We Dissent podcast, there is definitely a drumbeat theme. Everything we talk about, pretty much the answer is court reform, because not just in the religion clause space, but if you're paying attention and you care about secular issues, you probably are not thrilled with what the current Supreme Court is doing in several other areas, like environmental regulation and like civil rights laws and LGBTQ anti-discrimination protections. voting rights, I mean, gun rights, you name it. We are all reproductive rights, obviously, hugely. We are all living under the reign of a Supreme Court that is way, way out of step with what most of us want. And I think we've been conditioned to believe that our constitutional order is such that we just have to accept that because the Supreme Court is all powerful and almighty. And that's just not true. The Supreme Court, the federal courts, well, the Supreme Court is a co-equal branch of government in our constitutional order, along with the executive and legislative branch, which means it is subject, like those branches, to checks and balances on its power when it's out of step with what the people want. And so there is nothing radical about court reform. Is just another way of saying, in my view, what are the checks that we possess in our power as the people who power the entire democratic enterprise here. What are the checks that we have in our power to push back against what we view as, the majority of us view as, out of step with what we want? And that includes increasing the size of the court, which has been done several times throughout US history and is not radical. But it also involves other things like expansion of the lower federal courts, which as an administrative matter is long overdue. In other words, we don't have enough courts to hear all the cases we have in federal court. Congress could easily make more courts, more lower courts. It would help with caseloads, and it would also dilute the power of the judges that have been stacked there by political maneuvers that a lot of people think are undemocratic. So yeah, I think court reform for sure is something that we support at FFRF. I personally support it and talk about it any chance I get because I just don't think that it's radical or should be viewed as radical. I'm a big anti-fan of we can't do that because it's not the way we've done things in my lifetime. I mean, the Supreme Court is just one of three co-equal branches of government. There's nothing high and mighty about it. And we ultimately should wield our power to push back against what it's doing. Blah, blah, blah.
Yeah, so we got another question. What's your take on religious student organizations on a public school campus?
What is my take on religious student organizations on a public school campus? So this falls under the category of freedom of conscience. So religious student organizations are not only permitted, I think, by the Establishment Clause, but protected by the Free Exercise Clause, but with some important caveats, which are it's important that student organizations is not a tool used by teachers and other authority figures in schools to violate the Establishment Clause. In other words, it's religious organizations that purport to be student organizations should be truly student initiated and student led. In other words, they should be bona fide student endeavors. If they are, then I think that's all good. I mean, one of the important things, and we're talking about at the secondary school level, right? Because at FFRF, our view is that there's no such thing as a truly student initiated kindergarten Bible study. So, where the lower grade, the grade level, the more likely you are to be getting into the line between what the Free Exercise Clause protects and what the Establishment Clause prohibits, right? A teacher can't initiate a student religious group, and that that when you see it, and we see it all the time, especially in lower grade levels. But at the higher grade level, those groups are protected, and it's important for non-theist students and students of minority religions to understand that they're entitled to equal access on terms with religious student organizations that often have a lot of institutional clout and a lot of resources, but whatever they are getting, you are entitled to in your own group, humanist organizations, secular student alliance groups. You guys know all about this.
All right. There's a question in the chat. Do you support term limits on Supreme Court justices?
I do. That's another obviously idea in the bucket of Supreme Court reforms. I support it personally. I think FFRF probably supports it too, because again, it's one of the problems with our current Supreme Court is that it is stagnant, and it gets, I think lifetime appointments has made worse the problem of the politicization of the appointment process, right? Every appointment is a very high stakes, hyper politicized moment. And so I think term limits would dilute that. And of course, like breathe life into the bench and make it so that even when the court does things that are out of step with the majority of the people, it's not a 6-decade, sentence.
Do you have any opinions on the worst and best SCOTUS justices?
Do I have any opinions? Oh my gosh, it is so hard to pick a worst SCOTUS justice. Best, hands down for me, is Sotomayor. As you could tell from my presentation, she has just eclipsed RBG in now that RBG is gone as like just the staunch supporter of the actual people in these cases. Her dissent is the only thing coming out swinging for the actual people bearing the cost of what the Supreme Court is doing. So, I mean, you're seeing in these cases, like going way back to the Masterpiece case in 2018, and what we're going to see this term in 303 Creative, which involves, like I said earlier, this idea that the state anti-discrimination laws that apply to public accommodations, in this case, Colorado, and in Masterpiece, it was Colorado, the Colorado Anti-Discrimination Act, right? These wedding vendors, in this year, it's going to be a wedding website, wannabe wedding website designer. In Masterpiece, it was a bake shop. This court, it just can't wait to say that those vendors being forced to comply with anti-discrimination laws to be in business, that violates their free exercise rights, to deny service to same-sex couples. And the Masterpiece cake shop opinion completely left out the actual couple that was actually discriminated against in that case, and all of the LGBTQ people out there, Americans, who are going to be the victims of an opinion that greatly scales back their protections in the marketplace. So we saw in the Dobbs opinion, right? If you read that, Jem, twice in May, and then when it came down in June, you know that case just completely left out, the majority opinion ignored the effect that it will and is having on women and pregnant people. And same thing with the Kennedy case. Like, we heard all about Coach Kennedy and his rights and how they were violated and how he was punished and what a martyr he is. And we heard nothing about public school students and players on the team who are coerced and pressured. And it's just how icky it is to feel like you have to participate in someone else's religious practice in order to belong. But we hear nothing from the perspective of those groups in these cases. And Justice Sotomayor is the one writing the dissents, bringing those voices and perspectives and those people and their experiences to the fore. And so she is the best, in my opinion. I can't pick a worse, but it's Alito.
It's hard to pick a worse. How, I think it's a great question. How could the appointment process be improved?
Oh, this is so hard. I should
Maybe good
I should
question.
think about this more, because that's one I don't necessarily know that I've thought about just in the world of court reform. Because right, like there are a few things that truly are in the Constitution that would not be easy to change, because they're written into the Constitution. The size of the court is not one of them. Term limits, lifetime appointments, I think is. But the appointment process is not necessarily, except the fact that appointments have to be approved, with the advice and consent of the Senate. So you can't do away with that part. But you probably could tool around with the actual process, the hearing process, whether it's public, how that's done. And that, I have to think there are improvements that could be made there, because that has become such a spectacle. But I really think the more important piece, like the appointment process, wouldn't be so awful if you could somehow decrease the political significance of any given one appointment. And I think that's what the court reform package is about. It's about making the stakes lower for each individual appointment, to change how political and how partisan the entire court has become through the appointment process. So that's my best answer.
All right, thank you for that. We do have a couple more minutes, so if there are any last minute questions people would like to put in the chat, you are welcome to do so. In the meantime, I'll just remind folks that the next webinar that we have coming up, Black Free Thought from Slavery to Civil Rights, I'll type the link in the chat that you can use to register for that. It's our webinar page on our website. But really look forward to seeing you all there. Black and person of color voices are ones that we need to hear more of in this community. And so that's why we're putting on that webinar. We'd love for you to join us. And thank you so much, Liz, for being here with us. That was super informative. And it is sad to see the direction that the court is going, but knowing that the results of that decision don't completely wipe away the tests, at least, is good to know. We still have the tools, and see if we can use them. But do you have any final thoughts you want to offer?
Nope, just a reminder, you can report anything to us at FFRF. We're big team of attorneys there, just able to evaluate what you have going on, and just let you know what your rights are. And you can, again, check out all these resources about student rights at our website. And thank you so much for hosting me and letting me speak to you about these issues. I really appreciate it. Love the Secular Student Alliance. Always so happy to talk to you.
Thank you. And we love FFRF. We always turn to you all when our students have a legal issue, which they do too often. So thanks again for being here. Thanks again to the whole audience for being here. This will be available on our website, a recording, as is all of our, or many of our past webinars too. So please check those out on our webinar page. And thanks again so much, Liz. Thanks, everybody. We'll see you next.
Yes, thank you.
Thank you.
Now I'm downloading.